Welcome to Swanson Reed's presentation on the recent Absolute Vision Technologies Proprietary Limited and Industry Innovation and Science Australia decision handed down by the Administrative Appeals Tribunal of Australia in July 2022. This case involved the determination of whether the company's registered software development activities were eligible under the R&D tax incentive. The decision provides an important case study, as there have only been a limited number of previous decisions on software R&D eligibility heard by the courts and the AAT. It also aids in highlighting to potential claimants what types of evidence may or may not assist in establishing that eligible R&D has taken place. This presentation has primarily been based on the published AAT case description, which can be found on the Australasian Legal Information Institute website. In addition, Swanson Reed has published some commentary on the matter, which is available on our website. The links to these can be found in the video description. Published on the 21st of September, the case detailed the decision made by the AAT on the 13th of July 2022, which found that Absolute Vision Technologies, henceforth known as AVT, was incapable of proving that the activities it registered during the relevant years were eligible core or supporting R&D activities as defined in the Industry Research and Development Act 1986. In doing so, the AAT affirmed the previous decision made by Industry Innovation and Science Australia, or IISA. For some background information, the company had registered R&D activities with AusIndustry for the 2014, 15, and 16 financial years, with the stated objective of the project being to evolve available cloud-based management information software and advance it to a level capable of providing new products to Australian industry through leveraging the current NetSuite cloud technology platform and providing a more cost-effective and real-time multidisciplined business solutions platform. In December 2016, IISA informed AVT that it was conducting a review of its claimed activities for the 2012 through to 16 financial years to ensure compliance under the Industry Research and Development Act 1986. Following its review, IISA determined that the claimed activities for the relevant years were neither core nor supporting activities as defined in sections 355-25 and 355-30 of the Income Tax Assessment Act 1997. This meant that the activities claimed were ineligible for registration under the R&D tax incentive scheme, and AVT did not qualify for the refundable offset. Subsequent to this determination, AVT sought a review of IISA's conclusions. In arriving at its decision, the AAT considered documents such as the R&D registration documents, witness statements, and the expert evidence used by IISA. They also relied on the expert opinion of Associate Professor Raymond Wong, who, at the time, had over 23 years of post-PhD academic and industry experience in information technology. It must be noted that there was no challenge by AVT to diminish Associate Professor Wong's expertise or his ability to provide expert opinion to the tribunal in relation to the claimed activities. And Associate Professor Wong was the only independent witness to give evidence on the case. The AAT ultimately found that the claimed activities do not meet the conditions for eligible core or supporting R&D activities, noting that, overall, there is such a dearth of relevant or probative evidence that it renders AVT's activities incapable of assessment. Specifically, the AAT concluded, not only was there a lack of documentation and records, but there was a lack of witness statements and there was no oral evidence. And that, in order to qualify for the R&D tax incentive, the party must be seen to have engaged in research. That is, hypotheses need to have been identified and tested through a set of experiments or evaluations. The results of such experiments or evaluations are required to advance knowledge in the particular discipline. Based on the evidence before us, none of these requirements have been met. Associate Professor Wong asserted that based on the available material, A, AVT hadn't adapted to the research process in a systematic manner, and B, the steps taken by AVT were not based on principles of established science. In his opinion, the steps taken seem to incrementally add functionality to an existing system based on already known methodologies, techniques, and technologies to satisfy the customer or market needs. Associate Professor Wong concluded that ABT's approach did not constitute an appropriate scientific research methodology for the field of software system research and development. Furthermore, the AAT asserted that it is difficult to discern the specific activities for each relevant year, as the R&D applications describe the same activities in each year. Documentation to support that the outcome of experiments could not have been determined in advance by a competent professional were highlighted as being critical. It was noted that there was no evidence that ABT undertook a literature review in order to confirm that there was, in fact, any knowledge gap to be investigated during the company's experiments. Lack of clear hypotheses was noted as being a large impediment to establishing an eligible core activity, and evidence summaries outlining activities did not appear to be dated contemporaneously and succinctly to evidence the experimental process. This case brings to the forefront several key points to remember when attempting to claim under the R&D tax incentive. Firstly, it is important to identify clear and specific hypotheses that will be the subject of core R&D activities and that will seek to generate new technical knowledge. Secondly, it is important to investigate and document the state of worldwide knowledge relevant to an activity before it commences, why there is an unknown technical outcome that a competent professional could not have determined in advance and which can only be resolved by undertaking experiments, and where software is being developed on top of existing technology, it is important to describe the technological advancements being developed which intends to fill a specific knowledge gap. Lastly, contemporaneous documentation should be kept showing the experimental process, including the hypothesis and measuring of results, and the identified knowledge gap, and how the company determined that the outcome of the hypothesis could not be determined in advance. This case also highlights the importance of documenting and assessing activities in accordance with program regulator guidance, as to minimise the likelihood of ending up in dispute with the regulators. AusIndustry released new software R&D activity guidance around April 2022. That concludes Swanson Reed's presentation on the recent Absolute Vision Technology Proprietary Limited and Industry Innovation Insights Australia decision. Should you have any questions, please feel free to get in touch with our office. There is also additional material on recent cases and R&D legislation and guidance available on our website, as well as at the following links. Thank you.